Hello and welcome to Legacy IAS Academy. In today's video, we are discussing about a topic which is running into news. This is the competition law in India. Okay? So there are certain changes which has been introduced in the competition law in India, and the changes have been introduced to Competition Law Amendment Act of 2023. Okay? Who has brought these changes? It is the law. Okay? The Competition Commission of India itself, the Parliament has passed changes to Competition Law Amendment Act 2023, and as per this changes, whatever has been passed by Parliament, CCI has introduced these changes in the competition law also. Okay? The changes are applicable to the existing cases with CCI. So there are certain pending cases which Competition Commission of India is already dealing. All those pending cases, maybe some amendments will be carried out. Okay? Now moving on to what are the changes that have been introduced. Point number one. First is decriminalization of certain offences. So certain offences, certain petty offences ke liye, we have shifted, the law has shifted from fine to civil penalties, some kind of civil penalty. For example, you need to invest such and such amount in such and such sector. Some kind of civil penalties have been granted. Okay? Instead of imposing fine, civil penalties have been granted. That is the first change. Second change that has been introduced in the penalty itself. Okay? The total penalty will be approximately, or rather maximum, up to 30% of the company's turnover. Okay? So the amount of penalty, the value of penalty has been changed. The upper limit has been brought up to 30% of the turnover. Okay? Plus, the definition of this word turnover has also been changed. The definition has changed. So turnover, which meant earlier its presence, a company's presence within the country, that is within India, has now been changed over to global turnover. So if a company, let's say Reliance, is globally present across the world, so your global presence ka itna percent, 30% of the turnover of whatever you are earning across the world, that will be your penalty. Okay? So we have changed the definition of the word turnover from India to global definition, okay, to the global world. Third change that has been introduced in Competition Commission of India itself, that your penalty will be waived off. Your penalty will be waived off if a company or an individual informs about formation of a cartel in a different unrelated sector. Okay? So cartelization is never liked by Competition Commission of India because it will lead to monopoly of the market. Okay? So to avoid cartelization, they have come up with a leniency plus provision. This is the leniency plus provision, which says that if you are informing us about any other cartel which is being formed in any unrelated sector, unrelated to your sector, so we will be waiving off your penalty. Okay? That is the third change. What about the fourth change? Fourth change is about mergers. So let's say companies are merging. So iske liye they used to seek permission from CCI. Competition Commission of India used to grant permission for this. Now this time, which was in 210 days, CCI could take decision in 210 days, has been brought down to a maximum of 150 days. Within a period of a maximum 150 days, CCI must decide whether they have to approve or disapprove the merger. Plus, all the mergers which are beyond 2000 crores. Okay? All the mergers which are beyond 2000 crores must be approved by CCI. Okay? So these are the changes that have been introduced. Now, what are the consequences of this change? Is it considered to be good or bad? The challenges, the advantages. Talking about the first advantage, this is definitely going to improve the ease of doing business. Let's say if you have reduced the time required for merger from 210 days to 150 days, you are actually reducing red tapeism. Okay? The time involved in the governance procedure of mergers. Okay? Plus, it will also avoid cartelization because of the leniency plus provisions. Plus, it is CCI will also monitor all such mergers which are beyond 2000 crores. So mergers should not be leading to monopoly. That will also be ensured by Competition Commission of India. So definitely it is going to improve the ease of doing business. Okay? Plus, it will also be changing the definition. By changing the definition of turnover, okay, From India to global, we have improved the transparency and accountability. Obviously, transparency, accountability we have been able to improve, because the definition, now we are not talking about only whatever you are earning within the territorial restrictions. Whatever you are actually earning by your global presence, that will be considered as turnover. So the accountability and transparency of that company will also be increased. Okay? Third is prevention of market monopoly through leniency plus provision. That also we understood that leniency plus provision will avoid formation of cartels. Okay? So that can also be prevented. But what are the challenges? Now, Competition Commission of India, CCI, has its own challenges. Okay? We have observed across its years, since the time it has been formed, we have observed that it has a very poor success rate in defending its decisions. For example, Competition Commission of India has registered a case against XYZ company. So while registration Competition Commission of India was present, but while throughout the hearings, whenever the judges used to call whatever be the response from CCI, there was nobody to respond from the side of CCI. So they have not been able to defend their own decisions. Okay? Plus, appellate tribunals and higher courts. Okay? Their presence in appellate tribunals as well as higher courts, they have not been able to defend. That is one big challenge. Second is low rate of penalty recovery. Let's say we have given a penalty of maximum 30% of your turnover. Okay? But have you been actually able to recover this much amount of penalty? Iska rate is 0.4% in past 5 years. So obviously CCI has not been actually able to recover whatever penalty it has charged. Okay? Now moving to third challenge, CCI is also not very competent because it is scared about loss of FDI. So Competition Commission of India is basically trying to avoid formation of cartels, okay, and avoid market monopoly. So this is acting as a regulator of the market. Because it is acting as a regulator of market, it also has to ensure that its activity should not reduce investments to India. Okay? So with the fear of losing out on FDI, it is not ready to take some drastic steps. Okay? And fourth major problem is lack of manpower and resources. To stop anti-competitive practices, it is not having sufficient amount of manpower or resources, and the fear of affecting the sunrise sector such as food processing, processing, renewable energy, e-vehicles. These can be the examples of sunrise sector which are emerging sectors. So emerging sectors mein to merger acquisition will be, buying and selling of companies will take place very quickly. And if we are asking CCI to intervene into merger operations, we are actually hindering the progress of this renewables, these sunrise sectors. Okay? So these has been the challenges of Competition Commission of India. Now talking about the way forward of when we are writing answer related to changes that has been introduced in Competition Commission of India, what should be the way forward? So we need to definitely work upon the technical capacity building. So technical know-how of Competition Commission of India is quite low because of poor access to resources or manpower. So we need to work towards technical capacity building. Plus, we also need to set up separate bench of NCLAT, that is National Companies Law Appellate Tribunal. And National Companies Law Appellate Tribunal is the appellate body. So for any kind of complaints, we have National Company Law Tribunal, and the appeals against this will be lying at NCLAT. Okay? So NCLAT will be looking after the early adjudication of anti-competitive practices. So for example, any anti-competitive practices are ongoing and a case has been registered with CCI. Okay? CCI took the case to NCLT, and so there should be a separate bench so that we immediately resolve the issues of anti-competitive practices. Okay? Plus, protecting. So let's say कि sunrise sector is a problem. CCI is worried about this fact कि if I over-regulate a sunrise sector, they may not be able to rise. Okay? So let us come up with separate set of laws of competition and merger and acquisition and penalties related to sunrise sector. We can come up with, or rather protect the sunrise sector. That includes aviation, renewable energy, e-vehicles, food processing, and etc. Okay? So they can be protected using separate legislations that can be done. Okay? Now talking about these bodies, that is Company Law Tribunal and Company Law Appellate Tribunal. The National Company Law Tribunal was created in 2016 as a consequence of Companies Act of 2013. So Companies Act 2013 was passed, and we also discussed that there should be a dispute resolution mechanism, for which we created this tribunal called National Company Law Tribunal. This was created in 2016 and is a quasi-judicial body. If we say a body is a quasi-judicial body, that means it is not having its own court of records. For example, Supreme Court, High Court, District Courts, they do have a court of records. They will maintain their past decisions that they have taken, and their next decision will be in reference to the previous decisions. Okay? So, for example, Keshavananda Bharati case is a very important case. Maneka Gandhi case is a very important case, and for every next judgment, court judges will be referring to either Maneka Gandhi case or Keshavananda Bharati case, or depending upon their domain in that area, whatever has been the previous cases. But quasi-judicial bodies, they do not have their own court of records. Okay? This is a quasi-judicial body having 16 judicial members and 9 technical members talking about the corporate world, which have a good knowledge and know-how about the corporate world. Okay? What are the jurisdictions of Company Law Tribunal? First of all, it deals with matters pertaining to company law. So, company law may merger, acquisitions, amalgamations, compromises, all of this is looked after by NCLT. Okay? And all the disputes of all these situations will be taken care of by National Company Law Tribunal. Okay? Plus, we have an insolvency bankruptcy code. Insolvency bankruptcy code came up with the idea of Chakravyuh challenge. Chakravyuh challenge. Chakravyuh challenge, which was discussed in economic survey, says that in India it is very easy to open up a company, but very difficult to close it down. Okay? So, Chakravyuh challenge ko resolve karne ke liye, that means if you have to close down a company, we came up with a set of laws called the Insolvency and Bankruptcy Code. And any dispute related to IBC ke liye bhi, that is the Corporate Insolvency Resolution Process ke liye bhi, we need to refer to NCLT. Okay? Plus, winding up of a company, whether it is voluntary winding up or involuntary or compulsory. So, let's say a company has taken loans from bank and it turned out to be bankrupt. It turned out to be a non-performing asset, NPA. So, we may have to compulsorily close down the company, or by voluntary, by the company owner themselves have asked that please liquidate my assets in this company. Okay? So, whether it is voluntary or compulsory winding up of the company, that will also be taken care of by NCLT. So, NCLT will pass an order that we need to wind up this company. Okay? Plus, incorporation, dissolution and functioning of limited liability partnership will also be approved by National Company Law Tribunal. And LLPs or limited liability partnership is different from a normal company. LLP may the company which is being run by these limited liability partners, okay? This is a different entity. So, let's say a company owner can switch, can change, can go out or in of this company, and this is not going to affect the company. Okay? But in case of a normal company, which is not an LLP, limited liability partnership nahi hai, so because their liability is not, it is not limited, it is unlimited. So, you totally need to own the company. If you are dead or you are going out of the company, then the company may be closed down. ठीक है? ये problem LLPs के साथ नहीं होता है. ठीक है? So, LLP का incorporation, dissolution or functioning of all LLPs will also be taken care of or will be approved by the National Company Law Tribunal. Plus, class action suit. Class action suit refers to a condition wherein shareholders of the company have taken their own company to court. ठीक है? For example, there are shareholders of a company ABCD. ठीक है? This is the company ABCD. And there are 4 shareholders to this. ठीक है? So, these shareholders got to know that rest of the shareholders or the company board member have taken a decision which was not informed or which was not asked by the shareholders. ठीक है? So, in that case, they can file up a class action suit against their own company. So, a group of shareholders or depositors, if they file a lawsuit against their own company, this will be called as class action suit. ठीक है? Then we also have appellate authority against, so a National Company Law Tribunal will also be acting as an appellate authority. So you can file the appeal against SEBI or Competition Commission of India or Registrar of Companies. In सबके खिलाफ appeal will also be coming up to National Company Law Tribunal. ठीक है? So this was about NCLT. Now about the appellate body, the body which is above this. This was also established in 2016. Same. The NCLT was also established in 2016. This appellate body has also been established in 2016. Both of them have been set up under Companies Act of 2013. Both of them are quasi-judicial body, and it is the appellate authority against National Company Law Tribunal. Okay? The appeals against NCLT can come up to NCLAT in a period of maximum 45 days. And if you have to appeal against the decision of National Company Law Appellate Tribunal to Supreme Court, this can be done within a period of maximum 60 days. Okay? Now coming to the last part, which is the Insolvency and Bankruptcy Code. Okay? As we discussed, Insolvency and Bankruptcy Code emerged with the idea of Chakravyuh Challenge. Chakravyuh Challenge, which was discussing it is very difficult to open up a company in India, but very easy to open up a company in India, but very difficult to close it down. Okay? So there are governance, red tapeism related issues plus bank related issues that we are not able to close down the company. So Insolvency and Bankruptcy Code was introduced to address the rising issues of non-performing asset. How does it do that? So by it provides a time-bound resolution. Within this much period of time, you need to do this. Okay? Shift of control from debtor, that is the company owner. Okay? Whoever is the owner of the company, he is the debtor because he has taken loans, to creditor. So now the ownership will shift to the hands of whichever bank from which the loan was taken. Okay? Plus revamping the corporate distress resolution process. The corporates are too much under distress. Okay? And how do you resolve the problem of this corporate sector? Isko revamp karne ke liye bhi we have this Insolvency and Bankruptcy Code. Okay? But what are the challenges? We'll be coming back to the challenges. Let us first discuss about the steps that are involved in insolvency and bankruptcy. First, we need to file a CIRP petition before the National Company Law Tribunal. CIRP stands for Company Insolvency Resolution Process. Okay? So, corporate insolvency resolution process. So, iske liye, first of all, I am filing, State Bank has filed CIRP against company ABCD. Okay? ABCD, that it took loan from me and it is not able to perform. It is not able to generate profit and it is not able to return my loan. Okay? So, first of all, corporate insolvency resolution process ka petition is filed before NCLT. Okay? Now, this will be accepted by Company Law Tribunal. Until and unless Company Law Tribunal has not accepted this, we will not be able to proceed with Insolvency and Bankruptcy Code. Followed by this is appointment. NCLT itself will appoint an insolvency professional. So the professional will come and help me कि आप ऐसे से कर लीजिए, this much part of the company you invest in this sector, this much part of the company. So all in all, the entire process of insolvency has to be carried out in the presence of a person who has been designated by the Company Law Tribunal. Okay? Then IP, that is insolvency professional, will go for constitution or formation of COC by the interim IP. Okay? Now this COC will actually help me that this much percentage of your company is profitable. So you proceed with this much percentage of the company. This is not profitable, so you sell it off. Or let me help you fund this much so that this becomes profitable and the entire company runs. Okay? So whether the company should be added to more, with more funds, or do we need to liquidate that? All of this suggestions and advices are coming from COCs. Okay? Then we have appointment of resolution professional. Resolution professional say the process of insolvency and bankruptcy begins. Okay? So whatever be the advices that have been coming from COCs will be accepted by resolution professional, and then there will be a resolution plan which will be finalized by the resolution professional. Okay? Then this has to be accepted by COC, which was the original body which recommended RP, resolution professional, that aap aise kar lijiye, you need to do this. Okay? And finally, the submission of resolution plan to National Company Law Tribunal. Finally, the plan has to be submitted to NCLT and then the resolution process will be completed. Okay? So these are the steps of Insolvency and Bankruptcy Code. And we came up with the idea कि a maximum of 330 days can only be allocated for the resolution, for the insolvency and bankruptcy process. ठीक है? So it was promised that 330 days के अंदर we need to either close down the company or get the company running. That is less than 1 year. ठीक है? But on an average, we have seen that it is taking 724 days. ठीक है? 724 days on an average to complete the procedure of insolvency and bankruptcy. So that has turned out to be the biggest challenge of IBC. Okay. With that, we come to the end of this video. I wish you all the very best. If you have any doubts, please let us know in the comment box. Thank you so much.